Nevertheless, while we have an obligation to try to do something about it, there is a complementary obligation on the part of young aspiring lawyers to explain to the judges, to explain to the appointments commissions what it is that they find difficult about applying to become a judge, why they find it daunting, what are the chill factors, so that we together can seek to break them down. Ingrid has raised the possibility of a quota system. That, it seems to me, is the nuclear option. It may have to be resorted to, but as she has pointed out, what women and ethnic minorities do not want is the badge of tokenism, to believe or to consider that others believe, which is even more important, that you are where you've been appointed because of the ethnic background from which you come, or because you're female. And merit must always be the cardinal principle for appointment to the bench. But merit is an elastic concept, and we recognize, I think in the Supreme Court, even the disgusting majority of men recognize that what Baroness Hale, for instance, brings to the table is something that we can never bring. And likewise, the absence of an ethnic minority representative in the Supreme Court means that there is a gap. So I very much hope that with the cooperation that should exist between those who might aspire to judicial appointment and those who are responsible for making judicial appointment, that we can avoid what I've described as the nuclear option. But ultimately, it may be that resort will have to be had to that.
At the back.
On the question of affirmative action, redistribution, I'm curious, this was South African experience where, of course, redistribution is being done for the majority, not for minorities, and how South Africa managed to go forward.
It's been very difficult and it's been very controversial. And all the complexities that Lord Kerr and our chairperson have spoken about have been present there. There is, the Constitution says that everyone is equal before the law. There shall be no unfair discrimination, but it says that there may be programs in order to achieve equality for those previously disadvantaged by discrimination. It's under that constitutional clause that affirmative action legislation has been adopted. Now, the difficulty is that it's, and this is widely spoken about, that all the judges present in South Africa are black. One of them is a woman, and the judges present want judges who can do the work. So it is seen as a balance between getting representativity, what our young colleague here said, that, and the richness of having diversity in your own tea room, in your own deliberations, that you get an insight that you just don't get from someone who's black or who's a woman, that you can't bring. So you're enriched by the necessity of having other people in your judiciary, but at the same time, the work has got to be done. So the judges present are now, who, as I've said, are all black, are speaking out about the need to get people. We've got a difficulty in South Africa because there was a very, very strong pressure to appoint black judges. And many of them simply weren't able to do the work. And we've got backlogs, and there have been some cases where judgments have been delayed for 3 or 4 years, which is a very shameful thing, I think, in the judiciary. So it's that striving for excellence. And one of the things that they've done in South Africa, which I think is very interesting, is that there's actually a trainee women judges program. And a very senior judge who happened to be white, a very enormously experienced judge who was retired, he was over 75, he took on this program. And he took a group of 10 or 12 women and he trained them for 3 months, he gave them exercises, he brought many of us in to come and talk to them. They did exercises, they did writing exercises. The next step was that they went onto the bench with a sitting judge. And they wrote some of the judgments, they heard the arguments, they battled with the sitting judge with the decision and with writing the judgment. And after that, they were then asked to be acting judges, which you've got a different version of in the United Kingdom. And some of those women judges have now been appointed. And one of them is a very close friend of mine, whose children are my godchildren. And she was made a judge last year, and she's doing an absolutely wonderful job. She's now known as one of the hardest working and most successful young judges in the High Court in Johannesburg. So there are many things one can do sub-nuclear.
I'd like to ask about access to justice in the form of public funding for representation and access to legal advice. What's interesting about the panel we have today is the comparative nature. In England, as we know, big changes to legal aid coming forward, which many people in the legal profession are anticipating not joyfully. Now, what I'd like to know is the extent to which the countries represented on the panel look to each other for ideas, funding, and making legal advice and representation available. I'd like to know the extent to which, or not, they look to the United Kingdom for leadership on that front, and whether England is or isn't in danger of losing its position of leadership if indeed it has it. And finally, the extent to which we look to
In my country, for example, the crime rate is very low compared to that of neighboring countries. Ethiopia sharing border with Kenya at the southern part, comparing to that of Kenya, Uganda, Sudan, the crime rate is very low. And those criminals, they cannot afford themselves to hire a lawyer. On one side, there is constitutional right, access to justice, okay? And in this case, the government provides them free legal aid, okay? Especially for those criminals, okay? Offenders who have committed the most serious crimes like murder, okay? In all other cases, as a result of this financial constraint, the government is not in a position to provide free legal aid to all criminal offenders, okay? Because we have also constraint. And the other one is corruption is the most serious problem in Africa. Yeah, I don't know whether you heard about this story. Some years back, an international conference was held in Paris, Asia, and almost all African trade ministers were invited to attend the conference. And by the end of the conference, the host Asian minister invited one of his African counterparts lunch at his home. And this African trade minister found the house of the host Asian minister very big, very modern, well furnished, and asked him, how can you build such a big modern house with your salary? Okay? That Asian minister said, please come to the window, okay? Do you see that road? I do. 10% of the construction of that road is spent on this house, said the host Asian minister. The next conference was scheduled to be held in that African country, okay, minister. I'm talking about corruption, okay? Then by the end of the conference, the host African minister invited his Asian counterpart, again, lunch, his home. The Asian minister found the house of the African minister very big, even bigger than him, well furnished. People asked him the same question. How can you build such a big modern house? Again, to the window, come to the window. Do you see that road? Which road? No road. Yes, there is no road. 100% of the political is spent on this house. So the resource goes to corrupt people. So most criminals, they can't afford their service because, as I said earlier, those who are in power are living the next luxurious life. It's the real history.
Perhaps I could say a word or two about that. The problem of access to justice is a deeply troubling one, especially in these times of economic stringency. In the legal profession and law in general cannot escape making its contribution to the reforms that are necessary in order to bring us out of recession. But that must not be at the cost of denying to individuals the indispensable legal representation that they may require in order to ensure that justice to their particular cause is done. And of course, many of you will be aware that in a very important case coming from Ireland, case of Airy against Ireland, this problem was addressed in the European Court of Human Rights, where it was recognized that in order that justice to Mrs. Airy was done, she had to be provided with legal aid. And I fully anticipate that we are going to have cases in the near future where there will be a challenge based on the failure of the government to make available to individuals the necessary funds for legal representation. We've just been sitting in the Supreme Court in a case where this issue arose somewhat obliquely. It concerned a young man who had been summarily dismissed from his employment at the school, and he sought to be legally represented at the hearing of the Board of Governors, which was considering his case, and which in particular was making findings of fact in relation to the allegations made against him. And they were allegations of a sexual nature, and they potentially have the consequence that he will be placed on a list which will bar him from being employed to work with young people. And in the course of the argument, one of my colleagues asked the question, well, let us suppose we agree that he should be legally represented in order that his interests are properly catered for. And let us suppose he isn't able to afford it. Are you suggesting, he asked counsel, are you suggesting that the Board of Governors will have to pay for his legal representation? And very courageously, counsel said, yes, in certain circumstances, if you are going to be taking decisions in relation to an individual's future, and if he can only participate meaningfully in that decision-making process by having legal representation, and if he cannot afford to have it, well then yes. Now it's not a very palatable answer, but it does illustrate the tension between, on the one hand, imposing that burden on an authority like a school authority, which is not well equipped to meet it, and on the other hand, where you invest that body with the right to determine in a very real and meaningful way what the future will be for this individual, that's a prospect that you have to frankly confront.
Edwin, I think you should tell this audience about how the South African Constitutional Court has dealt with the problem of corruption in Africa. I think it's a very interesting case, Glenister, and how your court dealt with the ongoing problem of corruption.
We had a very interesting case last month where what happened in our country is that there was a very contested succession, and the man who became president had been put up on corruption charges, in fact, President Jacob Zuma, and he was charged and brought to court, and the charges for various reasons were withdrawn shortly before the election of 2009 that made him president. But one of his pledges, and part of his group's pledges, was to disband the corruption unit that had targeted him and various other high-profile politicians in the country. The unit was called the Scorpions. And they then did that very soon after the new government took power in 2009. And they abolished this group, which had been under the National Prosecuting Authority, which is a constitutionally protected independent organ. And they created a new unit that was in the police and reported to the National Commissioner of Police and reported with the National Commissioner to a group of 5 cabinet ministers. And someone brought an action to say that this was constitutionally invalid. And the basis of the challenge was the United Nations Convention that South Africa had signed, the 2000 Convention Against Corruption. And the convention says that you've got to have a sufficiently independent anti-corruption unit in your country, and South Africa signed this.